Thanks everyone for joining our annual required sexual harassment training. In this training, we're going to review an overview of sexual harassment, definition of sexual harassment in the workplace, quid pro quo and hostile work environments, Capstone's policies, expectations at work, retaliation, our manager's responsibility, how to report sexual harassment, and what that looks like, investigation, process, and corrective action, and then we'll do a summary of what you should have taken away from this training. Everyone should have received copies of our employee handbook on their first day of employment. It's also accessible within Lifion, and you can shoot an email to anyone in the HR team and ask for a PDF copy that we can email you. Sexual harassment in the workplace. So Capstone is committed to ensuring that all individuals have an equal opportunity to enjoy a fair and safe, productive work environment. Laws and policies help ensure that diversity is respected and that everyone can enjoy the privileges of working at Capstone. Preventing sexual harassment is critical to our continued success, and sexual harassment will not be tolerated. This means any harassing behavior will be investigated and the perpetrator or perpetrators will be told to stop. It also means that disciplinary action may be taken if appropriate. If the behavior is sufficiently serious, disciplinary action may include termination. Repeated behavior, especially after the employee has been told to stop, is particularly serious and will be dealt with accordingly. This training will help you better understand what is considered sexual harassment, and these reports will be taken seriously and promptly investigated, with effective remedial action taken when appropriate. So, the definition of sexual harassment. Sexual harassment is a form of sexual discrimination and is unlawful under federal, state, and local law. Sexual harassment includes harassment on the basis of sex, sexual orientation, self-identified or perceived sex, gender expression, gender identity, and the status of being transgender. Sexual harassment is unlawful when it subjects an individual to inferior terms, conditions, or privileges of employment. So then we'll go over quid pro quo and hostile work environments. So quid pro quo is sexual harassment that means that a manager or supervisor may not tell an employee that in order to receive a promotion, a raise, or any other job benefit, or even avoiding something negative like discipline or unpleasant assignments, that the employee must do something sexual in return. Harassment doesn't need to be severe or persuasive to be unlawful. Any of the harassing conduct described in this training can be unlawful unless it's shown to be more than petty slights or trivial inconveniences. So, what is a hostile work environment? A hostile environment on the basis of sex may be created by any action previously described, in addition to unwanted words, jokes, pranks, physical action, or violence, either of a sexual nature or not, directed at an individual because of their sex. Hostile environment sexual harassment includes sexual or discriminatory displays or publications anywhere in the workplace, such as displaying pictures, posters, promotional material, reading material, or any other materials that are sexually demeaning or pornographic. This also includes sexual displays on workplace computers or cell phones, and sharing those displays while in the workplace. This also includes sexually oriented jokes, noises, remarks, or comments about a person's sexuality or sexual experience. Hostile action taken against an individual because of that individual's sex can also include rape and sexual battery, molestation, or attempts to commit these assaults. It also includes physical acts of a sexual nature, including but not limited to touching, pinching, grabbing, kissing, hugging, brushing against another employee's body, or poking another employee's body. This also looks like interfering with or destroying a person's workstation, any equipment, or any way interfering with that individual's ability to perform the job. This can also be sabotaging an individual's work or even just bullying, yelling, or name calling. So, unwelcome behavior. Sexual conduct becomes sexual harassment when the behavior is unwelcome. Behavior that is unwelcome in the sense that the victim does not solicit or invite, um, in the sense that the victim regarded that conduct undesirable or offensive. Welcome behavior can also turn into unwelcome behavior. It might start off as welcome behavior or consensual joking, but as soon as you cross a line, it then becomes unwelcome behavior. Also, consent can be revoked at any time. When someone's experiencing sexual harassment and they say, "Stop talking to me like that," it must stop. The perpetrator also can't go back and use the defense of, "Well, you started it," or "You were okay with it at first." So, Capstone's policy. We are committed at Capstone Logistics to providing a work environment that is free of illicit harassment. As a result, the company maintains a strict policy prohibiting sexual harassment and harassment against applicants and associates. The company's anti-harassment policy applies to all persons involved in our operations, regardless of their position, and prohibits harassing conduct by any associate of Capstone Logistics. This includes supervisors, managers, and non-supervisory associates. Expectations at work. So sexual harassment can occur whenever and wherever associates are fulfilling their work responsibilities, including at the office, associate-sponsored events, conferences, office parties, even offsite non-work hour events that are an extension of the work environment. So this includes conferences, recruiting fairs, any travel for the company. Sexual harassment can also occur between any individuals, regardless of their sex or gender, and can occur between opposite sex. The law protects associates, paid or unpaid, non-employees that are still in our workplace. Sex stereotyping. So this occurs when conduct or personality traits are considered inappropriate simply because they may not conform to a person's idea or perceptions about how individuals of either sex should act or look. Harassing a person because that person does not conform to gender stereotypes to appropriate looks, speech, personality, or lifestyle is sexual harassment. Harassment, because someone is performing a job that is usually performed or was performed in the past, mostly by persons of a different sex, is also sex discrimination. So, retaliation and protected activities. Any associate who engaged in protected activity is protected by law from being retaliated against because of any said protected activity. Protected activities in regard of harassment include making a complaint to a manager or another person designated by your employer to receive complaints about harassment. It includes making a report of suspected harassment, even if you are not the target of that harassment, filing a formal complaint of harassment, opposing discrimination. It also includes assisting another employee who is complaining of harassment and providing information during a workplace investigation of harassment. That can include testifying in connection with a complaint of harassment filed with a government agency or in court. So, what is retaliation? Retaliation is any action taken to alter an associate's terms and conditions of employment, such as demotion or creating a harmful work schedule, because that associate engaged in any of the above protected activities. Such individuals should expect to be free from any negative actions by supervisors, managers, or the employer motivated by these protected activities. Retaliation can be any such adverse action taken by an employer against the employee that could have an effect of discouraging a reasonable worker from making a complaint about harassment or discrimination. The negative action does not need to be job related or occur in the workplace and may occur after the end of the employment, such as an unwarranted negative reference. So, what is not retaliation? A negative employment action is not retaliatory merely because it occurs after the employee engages in protected activity. Associates continue to be subject to all job requirements and disciplinary rules after they have engaged in such activity. So, what are our managers' responsibilities? So, managers are held to a high standard of behavior, and this is because you're in a place of position of authority by the employer and must not abuse that authority. Managers' actions also can create liability for the employer without the employer having any opportunity to correct that harassment. They are required to report any harassment that is reported to them or which they observe, and managers are responsible for any harassment or discrimination that they should have known of with reasonable care and attention to the workplace for which they are responsible. Managers are also expected to model appropriate workplace behavior. Mandatory reporting. So, any managers or supervisors must report any harassment that they observe or know of, even if no one is objecting to that harassment. If a manager receives a report of harassment or is otherwise aware of harassment, it must be promptly reported to the employer without exception. This is even if the manager thinks the conduct is trivial or if the harassed individual asks that it not be reported. Managers will be subject to discipline for failing to report suspected sexual harassment or otherwise knowingly allowing sexual harassment to continue. Supervisors and managers will also be subject to discipline for engaging in any retaliation. So, what should you do if you are harassed or you observe harassment? We cannot stop harassment in the workplace unless management knows about the harassment, so it's everyone's responsibility. You're encouraged to report harassment to a manager or any other persons designated by your employer to receive complaints as outlined in our sexual harassment prevention policy so that we can take action. Behavior does not need to be a violation of law in order to be a violation of company policy. We will provide you with a complaint form to report harassment and file complaints, but if you're more comfortable reporting verbally or in any other manner, we are still required to follow our sexual harassment prevention policy by investigating these claims. If you believe that you've been subjected to sexual harassment, you are encouraged to complete the complaint form and submit it to myself or any other human resource representative within Capstone's team. You can also make these reports verbally. Once you submit a form or otherwise report harassment, our company must follow its sexual harassment prevention policy and investigate any claims. You should report any behavior you experience or know that is inappropriate, as described in this training, without worrying whether or not it's an unlawful harassment. Individuals who report or experience harassment should cooperate with management so a full and fair investigation can be conducted and any necessary corrective action can be taken. If you report harassment to a manager and receive an inappropriate response, such as, oh, just ignore it, you can also take your complaint to the next level outlined in our policy. Finally, if you're not sure that you want to actually pursue a complaint at the time of potential harassment, make sure that you're documenting the incident so that it stays fresh on your mind in case you do decide to end up filing an official complaint. So Capstone's investigation policy. It's our duty to take appropriate steps to ensure that harassment does not occur in the future. So here's how we actually investigate our claims. HR will conduct an immediate review of the allegations and take any interim actions as appropriate. Relevant documents, emails, phone records will be requested and preserved. We'll also conduct interviews with any parties involved or witnesses. Our investigation is documented and outlined in the sexual harassment policy, and the individual who complained and the individual or individuals accused of sexual harassment are notified of final determination and that appropriate administrative action has been taken. So our investigation and corrective action is going to say that anyone who engages in sexual harassment or retaliation will be subject to remedial and or disciplinary action up to and including termination. Capstone will investigate all reports of harassment, whether information was reported verbal or in written form. An investigation of any complaint should be commenced immediately and completed as soon as possible, and the investigation will be kept confidential to the extent possible. Any associate may be required to cooperate as needed in an investigation of suspected sexual harassment. And it is illegal for employees who participate in any investigation to be retaliated against. The United States Equal Opportunity Employment Opportunity Commission, otherwise known as the EEOC, is where you're actually able to file a complaint within 300 days from the alleged sexual harassment. A complaint filed with the EEOC has to be done before you can file in federal court. And if you want any more information about that process, you can visit www.eeoc.gov if you choose to do so. Other types of workplace harassment. So workplace harassment can be based on other things, and it's not just gender or inappropriate sexual behavior in the workplace. Any harassment or discrimination based on a protected characteristic is prohibited in the workplace and may lead to disciplinary action against the perpetrator. This includes age, race, creed, color, national origin, sexual orientation, military status, sex, disability, marital status, domestic violence victim status, gender identity, or expression. It also includes familial status, predisposing genetic characteristics, and criminal history. Much of the information presented in this training applies to all types of workplace harassment. After this training, all of our employees should understand that we discussed how to recognize harassment as inappropriate workplace behavior, the nature of sexual harassment, the idea that harassment because of any protected characteristic is prohibited, the reasons why workplace harassment is employment discrimination. They should understand that all harassment should be reported. Again, managers and supervisors have special responsibility to report harassment. With this knowledge, all employees can achieve appropriate workplace behavior, avoid disciplinary action, and know their rights and feel secure that they are entitled and can work in the atmosphere of respected people. For any additional information, you guys can visit www.illinois.gov/DHR for the Illinois Department of Human Rights. Thank you again for joining this training, and please don't forget to record your attendance on the next step of this survey. Thank you, guys.